Good day, this is Don Gascoigne, Director of Ultra Estate Planning, here to explain to you the benefits of a revocable living trust in relation to probate and taxes and the exclusion of these government institutions. In each state, there is a probate court to discover the true beneficiaries of an estate if the owner passes away without proper documentation. With or without a will, the court is petitioned by the children to probate the estate so title to property and liquid assets can be transferred to them as rightful beneficiaries. The first action by the probate judge is freezing of the assets to prevent anyone from liquidating property or spending any money without the court's permission. The judge then solicits claims against the estate by placing an ad in the local newspaper announcing court procedure where all of your personal and private information regarding assets and beneficiaries are disclosed. This process takes on average 2 to 3 years and can cost the estate 5% or more of the gross value. So if your home, vacation home, and liquid assets total $1 million, your probate fees can be $50,000 or more. How can you avoid this process and avoid the exorbitant fees and delays? The answer is a revocable living trust that holds title to all of your property, liquid assets, and more. A revocable living trust is a document that you own, manage, and are beneficiary of while you're alive, but directs your loved ones to act on your behalf in the event that you lack mental capacity or die. As owner or settlor of the trust, you will control your estate just as you do now. The only difference is you retitle the assets to the name of the trust to avoid probate. As manager or trustee, you will manage your assets the same way that you do now. The trust is revocable, which means changeable, so if you want to sell your property or refinance, you can, or buy and sell assets, the trust allows you to do so. As the lifetime beneficiary, you are the only one that can benefit from the trust while you are alive. As owner, you will choose a successor trustee that will safeguard your estate if you lack mental capacity and transfer assets to your chosen remainder beneficiaries at settlement of the estate when you pass away. A revocable living trust also has tax benefits, eliminating capital gains and federal estate taxes for most estates. All appreciable assets that are held in trust are stepped up to current market value at the passing of the first spouse, so the surviving spouse can sell these assets and pay no capital gains taxes. You can hold title to as many properties as you want, and they will all receive the stepped-up basis. Stocks and bonds too. Federal estate tax is eliminated up to $22.4 million as the Revocable Living Trust preserves the deceased spouse's $11.2 million exemption that would be forfeited without the trust. The tax rate is 40 cents on every dollar over $11.2 million, so a $20 million estate without documents would be liable for a $3.6 million tax that is unnecessary and avoidable. So let's review the benefits of having a revocable living trust. The trust eliminates probate and its fees, delays, and the public exposure of your personal finances. The trust eliminates capital gains taxes and federal estate taxes. The trust eliminates forced asset liquidation of trust property, saving the family home or farm. The trust puts your loved ones in charge to manage your estate if you lack mental capacity. And the trust transfers all of your assets in the manner in which you choose to those loved ones in as little as 120 days. The Revocable Living Trust is the cornerstone of any comprehensive estate plan. Find out more at ultraestateplanning.com.